5, 4, 3, 2, 1. The only contentious cases the International Court of Justice bracket open ICJ bracket close can hear are cases between states full stop. Individuals have no right of direct access full stop. This is an important difference between the ICJ and other human rights institutions that allow some type of direct access full stop. This limitation reflects the state-centered view of international law prevailing when the statute of the ICJ's predecessor was drawn up after World War I full stop. It does not mean that energetic and imaginative counsel can never get individuals, clients' situations before the court, as Donald Donovan's work shows full stop. Still, it is a significant limitation full stop. The ICJ also issues advisory opinions on legal questions if asked by the General Assembly or Security Council or by another UN organ or specialized agency authorized by the General Assembly full stop. The court has made some important contributions to human rights processes through advisory opinions, as I will mention later on full stop para. There are no limits on the sorts of inter-state legal disputes the court can hear full stop. However, a few types of cases have provided much of its work full stop. More than half its cases have involved disputes over land frontiers and maritime boundaries full stop. South Africa generated 4 advisory opinions and 2 judgments full stop. The court has also served as a sort of constitutional court for the United Nations full stop. Several advisory opinions have established key principles regarding powers and functions within the UN full stop para. There have been a few ICJ bracket open and PCIJ bracket close decisions significantly contributing to human rights law, but historically they have been a small part of the docket full stop. To give an unscientific illustration, if you look at the indexes of the 5 recent volumes of the ICJ full stop reports covering 1994 to 1997 sitting in my bookcase, you'll see very few references to human rights full stop para. Those you do see are concentrated in dissenting or separate opinions of a few judges full stop. Thus, human rights issues have been an intermittent and not specially important part of the court's work full stop para. In recent years, there have been a few more such cases, helping to stimulate this symposium full stop. The court's responses have varied full stop. When faced with competing legal values, today's court does not necessarily give human rights claims special weight or authority full stop. It takes such claims quite seriously, but I do not see it as taking a uniformly pro-human rights approach full stop para. In some cases, human rights values obviously have been given great weight, full stop. In the two consular notification cases by Paraguay and Germany against the United States, it clearly was of central importance to the court that the cases ultimately involved convicted persons facing capital punishment, full stop. I think this significantly shaped both the procedures and the final result, although the court's task was made simpler by the fact that the United States admitted the core violation of the convention, full stop. I hope that Donald Donovan will address these cases, in which he played an important role as counsel for Paraguay and Germany, full stop. I will not go into them beyond indicating the general thought that the court handled those cases as it did, and reached some of the results it reached, because they involved the administration of the death penalty, full stop. For the court, this aspect was much more compelling than the arguments regarding state practice and the construction of the treaty advanced by the United States, full stop.